Hello and welcome to this ET Now special. I'm Nayantara Rai. Today I am in conversation with the Secretary of Ministry of Corporate Affairs, which has certainly been one of the busiest ministries in the 4 years of the Narendra Modi government, whether I look at Companies Act or I look at the Insolvency and Bankruptcy Code. Thank you, Mr. Srinivas, for joining us here on ET Now. Before I get on to the ordinance that was promulgated by the President, impacting SMEs as well as home buyers, 4 years of the Modi government coming to a close. Every ministry is coming out with its report card. As an observer of the economic policies, there has been a perception now, while the government has perhaps, the center has perhaps never been cleaner, there is no corruption or there is very little corruption. The same cannot be said for corporate India. Corporate governance under the scanner. Look at companies like ICICI Bank, Fortis, Manpasand, PC Jeweler. I could go on and on. Do you think the Modi government hasn't fared well when it comes to corporate governance? These are all very big companies, including ICICI. Look what's going on.
You see, we have a very strong architecture of corporate governance. There's no doubt about that. In terms of the legal framework, the type of requirements you have got in terms of disclosures, the institution of independent director, the various committees, the audit committees. So all the elements of corporate governance is there. But now how effective that corporate governance, in terms of operations would be, would depend upon the effectiveness of the board of management, would depend upon how proactive the shareholders are. And I think we are going through a phase of transition. By and large, even today we are a promoter-controlled, corporate sector, family-controlled corporate sector, and therefore the non-promoter group's interests, you will have to have that extra efforts to protect the interests of the non-promoter group. Now, I think with all these requirements and with further strengthening the corporate governance framework through the Kotak Committee recommendations, many of which have been accepted by the government, and SEBI has notified the new regulations, things will improve.
No, but Mr. Srinivas, you're talking about the efficiency and the efficacy of the board and the independent directors. So let me just ask you one pointed question, one that we've all been reading about on the front pages of newspapers for a while. I'm talking about ICICI Bank. You've got LIC as a board member. You've also got a bureaucrat of the central government as a board member. They're absent during board meetings, which has given a clean chit to Chanda Kochar. Then we find out how the government knew about it. You all had the whistleblower report. The government was caught napping and has done nothing.
No, I don't think we can reach any conclusion with respect to any particular case, be it even this ICICI, because when I'm talking about the overall architecture, how a particular board is functioning, there is an evaluation mechanism. You have a regulator. For a bank, RBI is the regulator, and how effective a management is and how effectively they're functioning is well within the mandate of the Reserve Bank of India.
But the central government's bureaucrat, who is the representative of the government of India on ICICI, skipped the board meetings. What kind of a message is the government sending out for corporate governance?
No, I think I'll not be in a position to comment on that. Whether he could have taken leave of absence for some valid reason. Very difficult to comment on that.
Okay. What about the fact that the government had whistleblower reports on ICICI? It turns out, 48 months ago and nothing has happened.
I don't think it relates to the corporate affairs, so it will be difficult for me to comment.
As a Secretary of the Corporate Affairs Ministry, do you think that perhaps we need to strengthen whistleblower acts? Look at the Infosys case, look at the ICICI case. Do you think perhaps there's a case for that now?
I think most of these things are there. Only thing is we'll have to see that they function very effectively. I think the independent directors institution is very critical. We'll have to really see that how independent an independent director is. What would be the qualifications, minimum qualifications an independent director would have to have, and what sort of capacity the independent director possesses. So I think we are also very seized of this matter, and some work is in progress with respect to developing a strong criteria for selection of independent directors, the manner in which they'll be selected,
But they will be held accountable.
what sort of eligibility criteria they should have, their appointment, their removal, all these aspects in their entirety will have to be looked at, and their accountability. So the question is, we have a lot of expectations from independent director, but an independent director has a limited role, would attend 4 to 6 board meetings in a year. How much is shared with the independent director? The independent director is expected to evaluate the functioning of the board. Have we empowered the independent director adequately to be able to discharge that function? I think these are things which are evolving.
Okay.
So I don't think we need to be pessimistic. We should question if something is not functioning.
Should you also not be questioning the recent phenomenon that we're seeing, that auditors just resign? They say there's something wrong, so they resign. Their accountability cannot end there. Should they not disclose? These are publicly traded companies. There are minority shareholders.
Yeah, I agree. I mean, if something is happening so abruptly, I think there's something wrong. Because if something is wrong with the company, you have enough instruments within the Companies Act where there are elaborate provisions in the Act which empower you to demand information from the company. And if the company is not cooperating, you have enough avenues to report to the board, to the audit committee, to the central government. So they should use those powers they have.
Let me just ask you outright, Mr. Srinivas, and we'll appreciate an upfront answer as well. Are you looking into these cases, whether it's an ICICI, for example? Let's begin with that. Is the government examining the role of Chanda Kochar and immediate family?
There's an allocation of business rules, and different ministries have different mandates. So I think the governance of a bank squarely falls in the domain of the RBI. This is my understanding. So if there's any deficiency in the functioning of the top management, and if that could jeopardize the interests of minority investors and public at large, because you'll have depositors, then RBI will have to look at it. And I'm sure they're looking at it. So if there are any issues, questions have been raised, but they'll really have to look at it.
Because SEBI is also looking at it.
Of course, SEBI will look at it, because if it's a company, and if it's a listed company, and if there are shareholders, SEBI will also have to look at it. But I said, as a bank, SEBI is looking at it as a listed entity, as an entity which has.
So aren't you looking at it as a corporate? You're not going to look at ICICI Bank as a corporate?
I think, there are clearly laid down mandates, and as a bank, primarily, I think the RBI is the proper entity. If all ministries start, pouncing on an entity, I think it will be chaotic. We really don't have to pounce. And,
Fortis is the other one that we hear about. Is the government?
What about Fortis?
Is the government examining Fortis? The resignation of the auditor, the alleged siphoning of funds, its sale, how the overhaul of the company board that had to take place in the midst of the company sale?
So there are certain issues which the corporate affairs, through its organizations, is definitely looking into, and that's in process. So investigations, the findings will determine what action you need to take.
The last one I'll ask you about, Manpasand beverages. Are you examining that, the recent auditor resignation?
You mentioned about it, so abrupt exit of an auditor, certainly.
Okay, I'll now talk about the ordinance. It's a very proud moment for the government and for the country. A recovery of money is something that every Indian citizen will want. It will help the banking system, credit offtake, etc. It's a new law, so obviously there will have to be corrections that will keep taking place. Do you think now that by allowing promoters of bankrupt SMEs and MSMEs to bid will really help the system, will actually help in bringing the money back into the system?
I think it will be very efficacious. I think rightly that a special dispensation has been given. It's a very limited sort of relaxation you're given them. The only thing you're telling them is that you could bid, but then your resolution plan should be acceptable to the committee of creditors.
Yeah.
And it is felt that they best realize the economic value of the entity. It's not large enough to attract other players.
Yeah.
So if you don't do this, you will end up in foreclosure every
so many
second
jobs
company
will be
will actually
lost,
be getting liquidated. It will sell like a kabaddi, and then people will lose jobs. And if you look at the type of contribution they make in terms of employment generation, it's next to agriculture. So it's a huge employment generator. And they
the other employment generator, Mr. Srinivas, would be real estate. Of course, the market has been dead for over 10 years. I'm not going to get into that. Perhaps also dead not just of liquidity reasons, but the trust deficit that begins. IBC perhaps had not recognized the fact that there were thousands of third-party rights created with a real estate project, as JP Infra case had provided. Now you're saying home buyers will be equivalent to a financial creditor. My simple question to you is, you can't have banks agree among themselves for the last 4 or 5 years on how to turn around a company. How are thousands of home buyers of one project supposed to speak in one voice, in unison, and be at the negotiating table?
I think they'll have a voice in the decision making process, and they can influence the outcome. Insofar as how thousands of people can sit and speak in one voice, that's the bargaining power. If you'll have to organize yourself, and you'll have to channelize.
But is it practical?
I don't.
I get it's better than zero.
I don't think it's impractical as well. You'll have to have test cases, because I'm sure they all have one. They have one primary concern, that they get back their money, or they get the promise.
Some want their project, some want their flat, some want the money.
No. It's not. I really don't. Basically, I think the home buyer is more interested in getting back the flat.
Some want the money, Mr. Srinivas.
No. You see, somebody wants to exit, then I have no answer for them, because primarily the IBC is for resolution and not primarily for liquidation. Liquidation is the last option.
Okay.
And in liquidation, there's a waterfall, and you may not be better off in the liquidation scenario. You may be far better off in a resolution scenario.
Okay.
Because you can determine, when it comes to a liquidation scenario, if you're unsecured, you're nowhere. So I don't think home buyers should be myopic. They'll have to look at the big picture. They'll have to look at the long term, and what protects their interests, which is sustainable.
Because I've just coming from interviewing the housing minister, Mr. Hardeep Puri. He didn't know the operation metrics. So I'll ask you that. Would you allow more than one representative of the home buyers of the same project, or will it have to be one? For example, HDFC gets one representative, SBI hypothetically gets one. Can home buyers get two representatives?
So that mechanism, what we have said is that the mechanism will be worked out.
Okay.
Of representation. Why home buyers alone? Why not deposit holders? I mean, you have many people, who have the status of a financial creditor, and they're large in number.
Yeah.
You can be debenture holders. So they are equally important, and you'll have to have something which is manageable. Now, whether it has to be one, whether it could be two or more, it has to be manageable.
Mr. Srinivas, IBC so far has been spoken about those dirty dozen, the 12 cases which the RBI has wanted resolved expeditiously. There have been a lot of controversies around that when it comes to Section 29A related parties. A lot of the stakeholders and bidders and companies in question have decided to move the courts. Does the government today feel that when it looks at the original enactment of the Insolvency and Bankruptcy Code, that it has been diluted because of all of this, whether it's an Ultratech or an SR Steel or the Ruyas or the ArcelorMittal, etc., that have moved courts? You now have a situation where the 180-day deadline is not sacrosanct because of a court ruling. You have a situation where the court says the Committee of Creditors is not empowered to choose between an Ultratech and a Dalmia Bharat, as you guys had envisioned. Has there been dilution?
No, see, I'll put it this way. You see, let's not, I think it is a evolutionary process. In an evolutionary process, you will have certain things which are very constructive, you will have certain things which are destructive, and ultimately, the synthesis will be that something will come out. If things are improving, you should be positive. I think things are improving. What's happening with all these litigations and all these things, in some areas, the legal position is getting settled. In some areas where government felt that things are not going as they were envisaged, through ordinance also, we have tried to settle a few things now.
Okay.
We have tried to protect the sanctity of a bidding framework, So I think there's no question of dilution. It's a question of calibration and recalibration.
Because that 180-day deadline, for example, is no longer sacrosanct. That's not good.
It is absolutely sacrosanct.
The NCLT has said in the Bhushan Energy case, it's not. That's precedence.
See, it is absolutely sacrosanct. Earlier, in the earlier regime, it used to take 4.3 years for an outcome to be there. If it is taking slightly over 270 days also, which is not an ideal situation, but it's far, far better than the 4.3 year situation. So I would say that even now, it's early days, and we are, mind you, we are dealing with long distressed assets. So
how do you keep a neutral view when I'm sure the best of lawyers are being sent and the best of experts are being hired by the likes of Ellen Mittal, KM Birla, the Ruiyas, everyone who has a very different view of what the IBC should be? How do you incorporate all of that and then figure out this is actually the best?
see, I think the determining factor is which gives you the best outcome. I don't think you have to be too rigid on many of these things. Okay, it's not some value system based thing. It's a question of outcome being the best and having a sustainable outcome and progressively improving. So today, for example, in section 29, we have recalibrated many things within those disqualifications. We have not diluted it. We have recalibrated it to see that competition is not marred in any manner. You have the best possible competition. What the origin of section 29A, you must not lose sight of it, and that was that a deeply entrenched promoter who's been perhaps guilty of mismanagement and oppression does not regain control with a deep haircut through a legalized system. So it was that singular objective of keeping away the undesirable person.
Isn't the problem that the person being found guilty of that relation is not being decided in the courts? It's being decided by a bunch of banks. For example, that's exactly what is happening in the New Metal case. The Ruiyas say that, you know, there is no relation, or we're a small strategic investor. Ellen Mittal says that it doesn't matter, I was a promoter in Uttam Galva. The courts didn't deem all of that. It was a bunch of bankers who got together in a room and decided that, right?
No, I don't think anybody is questioning the necessity of passing the litmus test under section 29A. I don't think anybody is questioning it. Yes, as a bidder, if I want to contest that I don't attract any of those disqualifications, I'm sure you let me do that in a legal system. It will lead to litigation, it will lead to wastage of time, but things will get settled once and for all.
Yeah.
So these are huge assets, 30, 40, 50,000 crore. These are big players. Okay, they are competing for this. There will be fierce competition, and one of its facets is everything is fair. In this sort of thing.
In love and war.
So they may go to the courts, they may go anywhere, and I think we should accept that. But that's settling down. I mean, if you look at even if you look at cases, okay, let us take Tata. Why don't you talk about a case where there's been a super success, and I wonder whether anywhere in the world in 48 hours, it is how many, 8 billion or what, I mean, if you convert it into billions of dollars.
The Tata Bhushan deal.
Tata Bhushan deal got transferred from one entity to another in 48 hours.
Yeah, but then you also have Alok Industries, for example, where there's a deep haircut.
See, you'll have to look at, so what I'm saying is, you'll have to look at a success story also. You'll have to look at failures also. You can't get elated by this and you can't get dejected by this. So you'll have to find the least common denominator. I think we are very much on the right track. I'm optimistic. Of course, we should not be over optimistic, but I think it will need more hard work.
You know, do you think that you'll have to revisit section 29A once these big cases are taken care of? Can you have such stringent related party transaction rules once the dirty dozen and the second list of the RBI goes? Because these are also the cases where the allegations of maybe the corporate bank nexus is also existed.
What I would say is that it will be difficult to be able to react to that at this juncture, that will it be different. But as I told you, the guiding principle is what gives you the best outcome. okay, and sustainable outcome. So in a particular case, you had mentioned one example you had given where you could have a better outcome by vitiating the system also, but that's not sustainable. It will be a one-off better outcome, but it will ruin the
new metal case you're talking
no,
about.
I'm not going to
the Ultratech.
whichever case that maybe you can guess.
Yeah.
But I'm saying
I want you to say
in a one-off case, if you break the system
Yeah.
and get a better outcome, that's not a better
But
outcome.
there are some bizarre judgments. I shouldn't use the word bizarre because I could be held in contempt of court, but some decisions which, you know, are difficult to understand. How can you have a bidder who is allowed to submit a bid after the last day? I'm talking about Liberty House bid that was allowed for a Bhushan company, says that I'm based out of the UK, I didn't know which Bhushan group company.
Yeah,
there are some outcomes which don't make, you know.
So those were not envisaged, they've happened. And I think the response has been that in the ordinance, you know, it has been made clear that the regulations will clearly indicate that a late bid cannot be accepted, that a late bidder, you can't negotiate with a late bidder, and that every stage and process will be well defined and sacrosanct.
Mr. Srinivas, before I let you go, you know, there's this, what we've all read about, how passports will have to be deposited, or willful defaulters, that you becoming more strict about leaving the country. For example, we all read about how Mr. Chanda Kocher's brother-in-law, for example, was not allowed to leave India. What exactly are the rules? Can you take us, what is the update on all of this?
Update on what?
When do you impound a passport, or when do they deposit a passport? What is it? Because, you know,
you see,
if you can give us clarity on this.
Typically that's something which actually goes, which is not really within our mandate. But
there was all this talk about how directors of NPAs, their passport details would have to be submitted, and there would be alerts at airports.
No, that's not. So basically here, as far as we are concerned, we are a repository of, you know, information about the companies, their directors, and we are in the process of having a major KYC drive for the directors. So we have about 33 lakh directors, and there will be a major KYC drive, and you will actually refresh all those you know, fields of information about a director, you know, and that will also contain.
When are you starting this?
It's on the verge of, it's on the annual, anytime it will roll out.
Who will drive the KYC?
So this KYC will be driven by steered by the ministry, and I expect that the chartered accountants and company secretaries, who are otherwise the certifying authorities, will have to diligently and religiously implement, you know, and see that it's a success.
How often will you want this updated?
No, so this is a one-time affair first. So you are, and in this you are saying that if you have a passport, you give those details. If you have a passport, you may have a slightly different KYC for a foreigner, and you will have a KYC for the national person, an Indian. And to start with, this will be done as a one-time affair, and then every year the plan is that along with the financial statements and annual reports you're filing as compulsory documents, why not file your KYC for the company and for the director?
Because you know, anyway, we're going to have Aadhaar for companies as well, right?
As a regular feature. That means today there are 2 mandatory forms which you have to file. Every company has to file. You will have 2 more little forms, basically an e-form, which basically talks about the company means physical presence, where is the physical presence of the company, and a few other details of the company, and about the director, the details about the director, the contact details, the address, you know, all those details you need, and you will have, you know, PAN and other things, and if something has changed, you will have to inform the change.
Is this a lesson you've learned from Nirav Modi and Punjab National Bank?
Not necessarily. I think this is a part of the lessons we learned when you're dealing with a large number of shell companies, and in the task force, you know, efforts to first eradicate the shell companies and then create a system which will prevent, you know, incorporation of new shell companies. I think it's a part of that exercise. Some of this, you know, new ideas have sprung up.
With that, Mr. Srinivas, I'd like to thank you very much for being so candid. Thank you.
Thank you.